Hello. Today I wanted to discuss with you something that I believe will help in your marital planning and estate planning, and that is the significance for many of us to enter into a prenuptial agreement prior to getting married. The reason this is connected to estate planning is that the surviving spouse in New York, whether or not there is a will that says, I give nothing to my spouse, has something that's called an elective share, which is the right to inherit 1/3 or $50,000, whichever is greater, from the surviving spouse. Again, if the spouse in the will provides absolutely nothing to the spouse, and even explicitly says, I want to disinherit my spouse, I want to give them nothing. Under New York law, the spouse that survives is still provided for that elective share, which is the 1/3 or $50,000, whichever is greater. So for many of those entering into a marital agreement, some of the relationships happen to be where one spouse is moneyed and the other one is not. Or, for example, let's say that you are engaged and your parents want to give you a gift of hundreds of thousands or millions of dollars, but they don't know about whether or not they trust your new soon-to-be spouse to be savvy with that inheritance that they may leave or an outright gift. So we know we can plan around it with having a prenuptial agreement, right? So it's very important in the prenuptial agreement to specifically address the right to inherit post-mortem, to specifically address the elective share. Are you waiving it or are you not? So this is something that's very interesting because I had a case that recently came up where the surviving spouse was not left anything. The decedent did not have a will, okay? Because if you have a will, you can, of course, provide, under most typical prenuptial agreement terms, it says that nothing in this prenuptial agreement prevents the spouse from leaving a gift under a will. But if they don't, and they have a prenuptial agreement that disinherits the spouse, right? That says, I specifically agree that I waive my right to the elective share and to all inheritance under, any state law or any right that I have, I waive it, and there is no will, that surviving spouse may be left without anything. So the moral of the story is have a prenuptial agreement that is reviewed and negotiated on your behalf with an attorney, that addresses intestacy, right? That addresses inheritance, and of course have an estate plan, have a will that goes along with what you and your future spouse, or if this is a postnuptial agreement, your existing spouse agrees with, something that is really your intent and not something that is happening because you did half planning, right? So meaning you had a prenup, but you didn't address anything, you didn't have a will. And so even though you may have intended to just have separate property during your marriage, but disinherit post-mortem, you didn't address that. And these are some very significant aspects. This is why you should work together with an estate attorney to review any prenuptial agreement that you may have and along with your will. All planning should be done in a coordinated effort so that these issues are avoided. At the law offices of Irina Yadgarova, we are very experienced with prenuptial agreements and, of course, drafting wills and trusts, all types of estate plans that are custom tailored to your specific needs. I hope this was informative and helpful, and I hope to hear from any of you that have any questions relating to these topics. Have a wonderful day.